So I got a job working for NASUWT, which is the teachers' union, although we know that there's the NEU. You may be more familiar with the NEU. The NEU recruits non-teachers as well as teachers, and it's probably about 450,000 members. NASUWT, just teachers, about 250,000, I believe. And I am the regional organizer for the East Midlands region of the union. So I cover bases in Nottingham. So we cover the entirety of the East Midlands from Lincoln on one side to Northamptonshire, up to Derbyshire and everything in between. And we have about, I don't know, about 30,000 members currently that we take care of. So I'm going to do a presentation on the new employment rights bill that the new government have introduced within 100 days of taking power. It's a significant piece of legislation. It's very detailed, and I'm sure you don't want to hear completely that level of detail, but it does represent a very significant attempt at the beginning of a reversal of some of the legislation that was introduced after Thatcher was first elected, and that wasn't changed by the Blair and Brown governments. And we've lived in a situation from the time. I think it's just coincidence that the trade union movement came under major attack once myself and Dave got active. I don't think the two are inextricably linked. But since then, we had a raft of anti-union legislation, which has approximately halved the number of members of unions within this country. And within this bill, there are some signs of that being reversed. So there's a presentation in front of you, a slide, first page of a slide. Jonathan Bacon is a colleague of mine, and I have decided to just borrow his presentation. So the Employment Rights Bill, what does the bill do? It is very detailed. Let me just say that there are conflicting views about the government's new Employment Rights Bill. According to the Federation of Small Businesses, it's a rushed job which threatens employment and growth. But according to Sharon Graham of Unite, it ties itself up in knots trying to avoid what was promised. And we discussed those two aspects, those two views during the conversation. It's certainly a comprehensive bill, which represents the biggest upgrade in employment rights for a generation at least. 158 pages, 119 clauses. It's not as long as the Equality Act 2010, but the Equality Act was not only about employment rights, and much of it was consolidating rights which were already in place. So there's two slides covering the headlines, if you like, of what the bill contains. Banning exploitative 0 hours contracts. Around 1 million workers in Britain are on 0 hours contracts, and that's out of about 33 million people who are currently employed. End unscrupulous fire and rehire. I'll cover that in later on. Day one right to claim unfair dismissal. Strengthening collective redundancy rights. Paternity and parental day one rights. Bereavement leave. Strengthening flexible working rights, and strengthening the duty to prevent sexual harassment. Some of those I'll focus on more than others during the presentation. Liability for harassment by third parties, very relevant within certainly teaching, where third parties are now defined as including students and parents. Strengthening the gender pay gap reporting. You'll see an extension of collective bargaining, and a number of other points there. What does the bill do for unions? you're talking about the repeal of the unused Tory Minimum Service Levels Act. That would be that a trade union, before it took strike action, would agree to maintain a certain level of service during the industrial action, and obviously to undermine that industrial action. We found that employers were not prepared to use it, but it is going to be repealed, unused. The repeal of most of the Trade Union Act of 2016. I'll just cover that. Let's talk about the unfair dismissal first of all. So I'll cover first of all the individual rights aspect of the bill. So currently, it's a 2-year qualifying period before anyone can claim unfair dismissal, except where it's connected to a discrimination or similar, or whistleblowing, or asserting a statutory right, like the right to receive the minimum wage, and so on. And a qualifying period has long been a cornerstone of the unfair dismissal framework in law. Between 1974 and 1979, it was a 6 months qualifying period. Since the 80s, it has fluctuated between 1 and 2 years, largely according to whether there was a Tory or a Labour government. Clause 19 of the Employment Rights Bill promises a substantial shift in how unfair dismissal protections are applied by removing the 2-year qualifying period and extending these protections to employees from the first day of employment. However, you probably would have read in the commentaries around the particular bill that there's discussion around having a probation period. So the 2-year period will be abolished no earlier than autumn of 2026. Once the change is made, it's clearly intended to be permanent. Section 108 of the Employment Rights Act of 1996, which gives ministers the power to change the qualifying period by making regulations rather than change a statute, will be repealed. And it is contentious that there is this exception around a probation period. The bill does refer to an initial period of employment, or IPE. It creates a regulation-making power that allows the Secretary of State to provide for a different standard of reasonableness to apply dismissals to dismissals that take place during that initial period. Now, in terms of the duration of that probation period or initial period of employment, that's not set out in the bill. And that's something for the Secretary of State to specify in regulations. The government that has indicated it currently favours a 9-month period. I mean, my comment on that is, in terms of a genuine probation period, 9 months isn't needed. 9 months is massively excessive to determine whether the person is up to the job or suitable for the job. However, even if the dismissal does take place during that probation period, it will still be possible for the employee to claim unfair dismissal. The employee will have to show that the reason for dismissal is either related to the employee's conduct or capability, or a statutory ban, or is some other substantial reason related to the employee. So despite the introduction of the probation period within the day one rights, there is still a right to bring a claim to an employment tribunal for those individual workers. And in terms of redundancy, if people are made redundant within the probation period, they can still make a claim to for unfair dismissal. So, I mean, my summary on that is it introduces an important right for people to claim unfair dismissal to an employment tribunal from day one. At the moment, people can be unfairly dismissed up to including 1 day short of 2 years of service. And and that will change from the introduction of the bill becoming an act. So there are some significant improvements there. In terms of how the probation period will work, I think it's important we get down that probation period to a reasonable period, significantly shorter than 9 months, and ensure that people are properly protected within that period. I mentioned before guaranteed hours contracts, 0 hours contracts, and how 1 million workers are under these contracts at the moment. I know of someone recently who went to get to work their shift for a company that delivers for Amazon, a courier company, and they were turned away. There was no work for them. So there are 1 million workers in a similar situation. Now, the position in terms of the bill on this is it is one of the most important provisions of the Employment Rights Bill. One of the difficulties, though, according to the various lawyers that have looked at the bill, of simply banning 0 hours contracts, is that a straight ban could be sidestepped by employers, giving employees a 1 hour contract instead, with no other hours being guaranteed. The bill deals with this over 11 densely worded pages by introducing a new obligation on employers to offer guaranteed hours contracts to qualifying workers. This applies to workers with a low number of guaranteed hours. Low, in terms of low number of hours, is yet to be defined. The specified reference period is yet to be defined. So there is a need for enormous levels of clarity about how this will work and how employers will potentially, and this is a fear of Sharon Graham as I understand it, by the process being so complex, employers will find a way just to work around it. So moving on. Collective redundancy rights are covered by the bill. Closing the Woolworths loophole. Essentially, what the Woolworths loophole was to define the establishment where the redundancies were taking place as just one branch of Woolworths, and each branch was counted as a separate establishment, rather than collectively counting the number of redundancies that were taking place within the organisation as a whole. And the Employment Rights Bill seems to be an attempt to resolve this issue by collectivising the number of redundancies that are being made across an organisation, to ensure that the consultation takes place, and the consultation needs to take place where there's more, at least 20 workers or more facing redundancies. If it's counted by branch, as in Woolworths example, they can avoid consultation with workers and workers' representatives. So now we're talking about moving to a situation where the establishment is defined as the whole organisation. So again, this will be, I think, an important change in terms of the position of workers and increasing levels of consultation. Fire and rehire. People here will be familiar with some of the scandalous actions by employers, P&O, I think, being the most noteworthy. So they dismissed around 800 of their UK-based crew members by a pre-recorded Zoom call in March of 2022, causing outrage across the political spectrum, even amongst Tories, who by then had had 12 years to amend the law, but had not done so. And you'll know that the P&O workers were replaced by workers from overseas at a rate of pay significantly lower than the UK minimum wage level. The basic position until now has been that if an employer wishes to change the contracts of a group of employees and those employees refuse to agree, the employer can dismiss them and offer re-engagement on the changed terms. as long as the employer has a sound business reason, consults and follows a proper procedure. A claim for unfair dismissal will be unsuccessful. In NASUWT, I'll give you an illustration of how it worked. We represent members not only in state schools, but in fee-paying schools. And at a set of fee-paying schools in Loughborough, there's a Loughborough Schools Foundation, 4 schools in that town. They, for reasons of profit, saving money, wanted to take our members, the teacher members, out of the teachers' pension scheme, because the teachers' pension scheme has a significant employer contribution. And so it asked people if they wanted to agree to a change in the terms and conditions around their pension, which removed them from TPS, as it's known. And of course, workers refused, because what they were being offered instead was a far poorer pension. So they were dismissed and then re-engaged on the new terms. We took 30 cases to an employment tribunal, and we've won the first 2. On grounds that the employer did have alternative ways in which they could achieve certain savings without taking people out of their pension scheme and without dismissing people, crucially. But those are few and far between. It's been difficult for any union and any union member to win at the employment tribunal. So how does the legislation change this? The bill will amend the law on unfair dismissal so that where employees are dismissed for refusing to agree to a change in their contract of employment or re-engage them on varied contractual terms, those dismissals will be automatically unfair unless the employer can show, 1, evidence of financial difficulties affecting their viability as an organisation, 2, contractual changes to eliminate those financial difficulties, and thirdly, the need to make the change was not reasonably avoidable. In addition, consultation and consideration of alternatives will still be required. P&O would have failed that test, or those tests, there's no doubt about it. And certainly in the case of the Loughborough, the small example of Loughborough, which affected only a couple of hundred workers, they would have failed as well. So although this is not a total ban on fire and rehire, it will still be possible to do it fairly by employers. The view amongst lawyers is that the exceptions which allow it to happen are very narrow. To all intents and purposes, the lawyers believe, the bill will make fire and hire unlawful. So that's fire and rehire. Collective bargaining. I said at the start that there's been a number of, if we take 1979 to 2024, we're talking about approximately half of the number of members in trade unions now as there were then. I think it's down to 6.1 million now. And that decline has led to fewer workers being covered by collective bargaining run by trade unions. Now, this should lead to some reverse in that. There are 2 provisions in the bill which will have the effect of significantly increasing the numbers of employees whose terms and conditions of employment are set via collective bargaining, presumably rather than individual consultation or no consultation. The first and most significant in terms of numbers is the Adult Social Care Negotiating Body, the first listed in the PowerPoint. It's estimated that this will set the terms and conditions for up to 2 million care workers, a sector with notoriously poor pay and conditions where union membership is low. The second one listed there, school support staff negotiating body. So this would be teaching assistants, office staff within schools, and so on, adding up to approximately 800,000 people, involving unions like Unison, GMB, and the like. So collective bargaining will cover those areas where, again, sometimes fairly patchy recruitment. And it will, crucially, in terms of the school sector, it will try to overcome the fragmented nature of bargaining amongst those group of workers that's happened due to academisation. So you can have, in the East Midlands example, 2,500 schools organised maybe between 100 employers, and those 100 employers can set their own, within a certain range, can set their own pay scales and terms and conditions that can affect school support workers in particular, far more than teachers, whose terms and conditions are more governed at a national level. So the school support staff negotiating body will comprise employee and employer representatives, a representative of the Secretary of State, and an independent chair who will have a remit to negotiate pay and terms and conditions and to advise on training and career progression for school support staff. And then that will then lead into inclusion in individual employee contracts. Secretary of State will also be able to issue statutory guidance following recommendations and advice from the body on training and career progression. So we're talking about here millions of additional workers being subject to collective bargaining, which hopefully will lead to better terms and conditions and pay being provided to them. Fairness, equality, and well-being. You may well be familiar with some of the recent legislation around the duty to prevent sexual harassment, which was introduced with effect from the 26th of October this year. So employers are now liable if they have not taken reasonable steps to prevent sexual harassment taking place within their workplace. And again, being a bit parochial now in terms of schools, there have been increasing numbers of incidents of sexual harassment committed by, in particular, students against staff, but also parents as well. And the employers under this legislation will be responsible for trying to prevent that behaviour, even though they are third parties. Flexible working. I don't really need to dwell much on this. The Tories introduced certain improvements before the last election. People can now make, for example, 2 requests in a given year rather than 1. But really, it still amounts to a right only to request flexible working. It's not a right to flexible working that's introduced. There are still the 8 business reasons that an employer can give as a reason for declining a request for flexible working. There have been cases in schools, for example, where a head teacher has been stupid enough to put in writing to a particular member to say that, you know, your request is rejected because we don't have part-timers in this school. So we were able there to run successful sex discrimination claims and help get a new head teacher for that school. Trade unions. This is obviously very, very significant. This is where we get to the point of a combination of the individual and collective rights that are changing. So there are key provisions within the bill. First one, in the bullet point there, employers will be required to provide employees with a written statement confirming their right to join a trade union. This is likely to mean that contracts of employment will include this in future. In the public sector, it's probably commonplace that that kind of arrangement takes place. Public sector trade union membership is much higher than in the private sector, but this will be for all places of work. The second point, and we all know about the struggle to get into the likes of Amazon. Trade union access agreements is a new concept. Unions can request an access to the workplace agreement from employers to meet members, recruit, support a member, or to facilitate collective bargaining. Disputes, for example, if the employer rejects the request, will be handled by the Central Arbitration Committee. Again, in a lot of workplaces we deal with, in teaching, this already happens, but it's by no means uniform. Even in education, within state education, you have academy chains that are so hostile to the union, they will try and block access to schools. But clearly this is more geared to some of those private sector targets of the likes of the GMB. Union recognition made easier. Well, the bill removes the requirement to show that at the application stage at least 50% of workers in the bargaining unit are likely to support recognition. That's the current standard required. It grants the Secretary of State a power to reduce the requirement at the application stage to 10% of workers within the bargaining unit, and possibly as low as 2%. And it simplifies the support required for recognition in a final ballot. That is, a simple majority of those voting is sufficient. That will inevitably lead to a significantly higher number of workplaces gaining union recognition, because the hurdles at the moment are significant to make it as difficult as possible to obtain recognition. And industrial action ballots, simplifying industrial action ballots. You'll know that the Tories impose thresholds, that those thresholds, in order to have a successful ballot, you need to reach those two thresholds in parts of the public sector before lawful industrial action could take place. If you didn't achieve that threshold, as I know very well in my union, action was not possible. The simplification is to remove those thresholds. So the requirement that at least 50% of trade union members entitled to vote in a ballot on industrial action, and in important public services, 40% voting yes, is to be removed. And that will be replaced with a simple majority of those voting will be sufficient to take industrial action. This is very significant. And as I said before, one of the greatest challenges is when organising industrial action is not getting a majority of those voting to support the action. The link to electronic balloting is fairly plain. Many of us may have had the experience of, we may do an indicative vote of some kind, and we may do that by email, and we get a fantastic turnout because people are used to that way of communicating, and it's easy. And then we experience, when we do the real thing, that the turnout is lower and sometimes below the threshold, because that involves a postal ballot currently. The postal ballot sent to an individual's home address, the individual then needs to find a post box and then post it. And some of our organising work around balloting, we've even sent members by email a kind of map of where their post boxes are, because a surprising number of people probably don't. Maybe at this time of year they do, because it's Christmas. Generally don't post letters or much else. So, and the Tories opposed moving to electronic balloting, because precisely it would aid turnouts in industrial action ballots. So we are moving, it appears, to a removal of the thresholds, going back to a majority figure, and also with the introduction of electronic balloting that will make action easier to organise and happen. Protection from detriment. In summary, there is a Supreme Court decision that says the basic legal premise is a union rep, for example, or a union member shouldn't suffer a detriment for carrying out the functions of that union or the activities of that union. But a Supreme Court judgment said that in essence, industrial action isn't one of those trade union activities. And so some form of detriment, there isn't a protection from detriment in that way. The bill includes the provision that trade union industrial action is trade union activity and the individual should be protected from detriment during that period. And the period of industrial action is extended from the current, I think it's 12 weeks, but it's extended to an indefinite period as long as the action continues. So that obviously is significant. I've covered the Minimum Service Levels Act. Even employers found it unworkable to the point where they didn't use it. But it will go. We're now at the stage where the Act is going through committees. And a lot of this won't become law until 2026, is my guess. And one of the things, there's quite a few amendments that are coming up. Some are ridiculous, others aren't. One of the amendments that is getting some traction, as I understand it, is extending the period of time to claim to an employment tribunal from the current 3 months minus a day from the date of the incident, which could be a dismissal, or it could be a date that the person was discriminated against last. So sometimes that period passes before the individual gets their claim in. Well, one of the potential amendments is extending 3 months to 6 months, which certainly would benefit workers who obviously have to obtain legal support, trade union support before preparing a claim. And there'll be further amendments as this goes through Parliament. But in summary, does it provide everything? Going back to Sharon Graham's statement, yes, there are problems with it. There are some complexities with it that are necessary. Does it represent a significant step forward for workers in this country and trade unions that they're organised in? Absolutely. And it needs to be built on. For example, one of the things that's a key thing is trade union facility time. Let me give you that example. And that's covered by the legislation. What it says is it sees a situation where there is a reversal from the current position. The historic position for the last 20 odd years has been a gradual reduction of trade union facility time to do the job alongside one's official job. That leads to a position where people are not properly represented, where the union isn't organised within a workplace, and so on. And it leads to a position where there are fewer activists around, trade union activists, and more work is being done by full-time officials like myself, which isn't the best solution for the union in terms of the lifeblood is its members in the workplace. So we are envisages a position where the local activist doesn't do work in their own time as much, that the person has easier and greater access to facility time. And the onus will be on the employer to provide a good reason to reject that individual's request for time off. The problem with it is, how do you enforce that? You enforce it through the employment tribunal system. And the employment tribunal system is currently in a situation where you might wait a year before your case comes up. And there are better ways of doing this that don't involve that kind of long wait for justice. For example, we should have a situation, certainly within the public sector, that take schools. All of these academy chains with their CEOs on mega money. Well, they should be. It should be absolutely a legal requirement. They recognise the trade unions in their given academy, and it should also be mandatory that a certain percentage of the income they receive from the Department for Education is given towards trade union facility time. The current position is that's entirely voluntary. So some academies will pay the 1% or 2% of income for trade union facility time. Others will refuse. So rather than going through the employment tribunal route, this legislation can be made stronger by imposing requirements such as that on employers. And then that will lead to a position where we have more activists in the workplace organising and doing the right thing. That's it, I think, in terms of the presentation.